to record our presentation today.
Perfectly, okay.
And do you have a PowerPoint that you wanted to show?
Well, I wasn't quite sure how to do that, so I'll just run you guys through that. I had asked in that last email that to just take you to the website. So if the case managers have access to their computers and they want to go there, I can do it from the our website, the Guardianship website, and that is.
Or we can show your computer screen.
Okay, you can show my computer screen.
Yep, it's gonna come up. I'm gonna hit you with change presenter, and a little box will come up asking you if you'd like to show your computer screen, and then we'll be able to see whatever you have on your screen. So if you have any HIPAA sensitive stuff,
no,
probably wanna
not on not on the website. So yeah.
So I'm gonna switch it over to you. And then Joseph is going to talk to us about professional guardianships, what those are, what that means, how one goes about getting a professional guardianship, and all the implications. So we'll put it over to you. I'm going to mute myself. We'll do questions at the end, and it's all yours.
All right. Let me go to, it says show my screen, and I click on that. Okay. And then, let's see, where do I go to from there? On air, showing screen. And I need to go up here to Guardianship front door. There. Is that it? You guys seeing it? The website?
Yes, we are.
Oh, okay, great. Okay. So yeah, this is the website that I refer to people who call in just to give them some background information on whether the referral is appropriate or not. And so this is really good information. It's up to date. And so over here, about us, it's about our mission, and then the drop down box, and then our guardians, basically just to tell you that that we are the guardians that work for Mental Health America are held to high ethical standards, and that we become certified through the National Guardianship Association, and we adopt and adhere to their standards of practice and ethics. And then we also belong to Indiana State Guardianship Association, which has taken these standards and ethics from the National Guardianship Association and adapted them to the Indiana Code on Guardianship. So then if we flip onto our services, adult guardianship services, just kind of some background information that we've served as guardian for incapacitated individuals since 1988. That's when we accepted a contract for the people moving out of the State Developmental Center into the group and waiver homes in the community. There was, a block of people there that were living there that had been, grew up there. The parents had given the state, of course, that took a state commitment to even live in the institution. And so they gave up their parental rights. And then, through the years, a lot of times that caused, the relationships with family or family involvement to dwindle to nothing. And so a lot of times, there's families that's just not been involved with that individual for many years. And when they moved out, they didn't have anyone available or appropriate. And so talking about the National Guardianship Association once more, they're pretty rigorous ethical standards. And part of what Mental Health America does that I think separates us from people just practicing guardianship, public John Doe or whoever who goes and gets guardianship of somebody, is that, we do become certified. And then, we look at our vision and stuff. We look that we become part of the team and that person, the person that we serve. And so, we practice person-centered care to try to provide the best care for all the clients. And then, if possible, we are moving towards emancipating them based on what they're able to do. Most of our folks, did come from the developmental center and, functioned at a level that, didn't allow them, to do that, or, it's going to be, their independence and their self-actualizations. It's not, probably will take a lifetime if that. And so, we do become lifetime guardians for them, for the people we took on. Then we clicked on guardianship services. Well, let's go down here. When a guardian is needed, the majority of the people that we serve, since 2015, we were also able. Well, let me back up a little bit. When we took on a block of people from the developmental center, that was due to the Department of Justice coming in and challenging the State Developmental Center on these folks and saying, who's going to do that? They don't have anybody involved. And that's when that was established that people needed that. And so, they set the FSSA, sent out a contract, and we got that contract in 1988. That has been a closed program in that we could not take on anybody else after we were assigned a certain amount of people, and if they passed away or whether anything, we couldn't backfill and take on somebody else. And so the state of Indiana was just looking to kind of a immediate solution to get the people moved out, and having someone follow them in the community. And so when people called in before that, needing guardianship services, we would have to tell them that we don't take referrals right now as far as being able to do anything right away, but we would put them on a waiting list just so that when we did our reports to the state, they would see that that was still an ongoing concern and need in the community. And so then in 2015, when the VASIA grant became available through the Supreme Court, and VASIA is an acronym, of course, for Volunteer Advocates for Seniors and Incapacitated Adults. So basically, the Supreme Court was responding to this tsunami of baby boomers going into nursing homes that were the most vulnerable. They were on state benefits and did not have family, and they were having some sort of dementia or incapacity that way. And so that's the main focus of the VASIA program. Although it is, the general definition is that anybody that has a mental disorder, dementia, or intellectual disability, developmental disability, that has been deemed by the court that they, are incapacitated and can't manage their own affairs and making medical decisions or managing their finances and other assets, and accepting treatment options. Most of the time, of course, the Supreme Court would like to have a family member or a friend or, a community member that knows the person, has been involved in the person's life before they became incapacitated, for those nursing home folks. But, we're finding that that's usually not the case, that most of the time the referrals that we get from nursing homes are those that, do not have any family members, or they're scattered across the United States and have not been in contact or involved with that person for several years. And even when we do have that information and contact information, we contact them to let them know in our due diligence, that we are an agency that's serving as a, guardianship service. They usually don't want anything to do with that, or and just, are overwhelmed by the whole thing that, they may be held responsible, to make the major life decisions for people. And so then that's when we go ahead and petition the court to do, guardianship for them. anybody can be a guardian. Just to tell you that, all the requirements in the state of Indiana right now are that an individual is 18 years old and has no felony or gross misdemeanor record. They can serve, can petition the court for guardianship, and then it's up to the court, to grant that guardianship. And this is where we come into, a real dilemma sometimes in, what we do as Mental Health America in offering what we call professional guardianship. And that we're part of the team, that we're doing the person-centered approach, is that many family members of the public that, go, get pressed or get told that they need to go get guardianship for a family member or a loved one, is really not educated about the court process and or what their ongoing responsibilities are. And so then you get, into some cases where, a person has a guardian, but they're still not involved, or, they're hard to, get in contact with. And, that we get a lot of calls where, they're referring to us because this person has a guardian, but, hasn't been involved, hasn't had any contact, and what can we do to take on successor guardianship is what it's called. And and that just involves contacting that person, asking, why they, what do they understand as their duties, and, and why they're not involved in the person's life. And this is a service that we can offer if they want us, and agree to us taking over as a successor guardian. And so that's kind of the role that we fill there. Establishing guardianship. Of course, guardianship is a legal process. Since a guardianship can remove considerable rights from the individual, we have to do our due diligence to show that, the person is not capable of making sound decisions on their own. And then in last July, it actually became part of the Indiana Code in guardianship language to, include the supported decision making. That formalized that. A lot of people had some questions and concerns about supported decision making, but that is something that we as an agency have, extended and practiced in philosophy and vision for anyone. That if there is a person who can function and have this alternative and least restrictive means of being served, that would be, the preference. So, that can be, power of attorney, having that person who is considered at that point capacitated to assign people and have them, sign a form and have it part of their record, that they, this person can make, they have the, durable power of attorney to make medical decisions for them if they're not able to, and, medical decisions, financial decisions, such as. And so, the alternatives to guardianship are pursued by Mental Health America and should be pursued before filing for guardianship. And just last July, it just became part of the code, like I said, and that's formalized that process and making sure that everybody's hopefully following those steps. The primary investigation, according to the National Guardianship Association, and what we adhere to, is that we address the individual's disability and how it affects the decision making, and then analyze those evaluations and then state and support an opinion about the need for guardianship, and then recommend and support living arrangement and treatment plans. Filing the petition is something that we partner with the Volunteer Lawyers Program, because of the way our grant is written and everything, and we don't have that expertise, to legally draw up that paperwork and those petitions for the court. And because the people that we serve, the target population we serve, are on, benefits, state benefits and stuff, we Volunteer Lawyer Program, arranges for us to have a pro bono attorney to represent us in court. And in Allen County, we usually have those hearings before Magistrate Hauk, and he has determined in the arrangement he's made with VLP that that a guardian ad litem be assigned. And so there's two people giving pro bono services, two lawyers and professionals. The guardian ad litem is not a representative for the client per se. It is that they just go and visit and do a face-to-face evaluation and file a report with the court that it is appropriate for Mental Health America to serve in the role of guardianship. And so when we do that, when we get the referral and all that information that's on that new client assessment, which I'll get into a little bit later, is available, and we process that. We turn that over to the VLP, who then works out a lawyer and a court date to be on the docket. That process can take anywhere from 8 to 12 weeks sometimes, most times. And that is if everything is going smoothly. And so we don't run into those situations very often, because it's amazing how we, go to court and then all of a sudden a family member comes out of the woodwork and wants to contest that, and so then the judge has to, rule a continuance and allow that family member to file for, because this person has already been deemed incapacitated by a physician. And so there's a need for a guardian, and so that family member, if they're going to contest that Mental Health America be that guardian, they have 90 days to file paperwork with the court and become, that representative for that loved one or family member. That usually doesn't happen then. They haven't been involved with the person's life or anything, and when they realize that the process and everything that's going on, is on them, they usually fail to see that through. That is at the point where we, a lot of times, will refer them back to VLP, because the VLP also exists for, for family members in the public to, to assist them in that. It's usually based on a sliding scale income for that person, for those court costs and everything. And it's the individual that's that's become incapacitated. It's their income that is the consideration, not the family member that is applying for it. So that's that, I think. Once the petition has been filed, then and everybody that has been listed on that petition should have noticed that there's a court date and a hearing is going to be there, and that they can present themselves and testify if they want to. So that's why it's real important for us to know, in this area and in the population that we serve, that that where this person's living, who's the residential provider, who's the case manager, those support services, through the Medicaid waiver or group home, or the care team at the nursing homes, so that everybody, including the individual, gets served that notice that a petition has been filed. Then a hearing is held, and we go to court. If it hasn't been written into the petition that that person is not able, because of a health, physical, or mental condition, to appear before the judge, because the judge really wants to see that person face to face and get a good idea of who we're taking on or what he's doing, to grant us guardianship. So that's real important. And a lot of times we've run into nursing home referrals where, the physician has written on his physician's order to the court that the person is able to attend the court hearing, and then the nursing home, because of their dynamics and staff and different dynamics like that, transportation, might send a social worker or someone from that agency, but the person's not there in attendance, and so that can complicate things for us and for the process, and the judge has very little tolerance for situations like that. And so just to keep in mind, because some of the questions that we come up with is that, the legal process for establishing guardianship takes a considerable time, and that it's complex and cannot be done quickly. And also that when you do become a guardian, when we become a guardian, we're not held responsible for the actions of the protected person. A lot of family members have that misconception that that they're going to be legally liable for something, especially if this person has had a mental illness and has acted out in the community and maybe even have a legal record with the law, local law. Um, so um, that's one thing that we try to clear up, with if we're trying to get the family member to do that, is that if that protected individual commits a crime, that they cannot be charged for the crime. Now, however, the guardian is held responsible then for our actions while acting as a guardian for that person, that we're doing what we are supposed to be doing according to the Indiana Code and to the VASIA grant requirements that we have signed on. And so that's why we are pretty involved with everybody that we take on to become part of that IDT, and making sure that everybody's on board. We have tried to present ourselves, as part of the team, and not to be, some people, get guardianship and then they become very heavy-handed. I don't know if you guys have experienced that or not, but it's kind of a power and control thing that's really not in the best interest of the person. They are not really thinking of the individual. It's just something that they are projecting their desires and their wishes for that person. And while they're convinced that that might be the best thing for the person that they've got guardianship for, it really isn't, when you have all the other community supports with the Medicaid waiver budget and case management and therapies involved. So those, a lot of times those rings of protections become, or those circles of protections, I should say, become rings of imprisonment for that individual. And that's why it's so important that, that we are looking at person-centered and being part of that team and really looking at the best interest of the individual. We'll go into the referral process. Here again, I kind of, talked about this already, but, it is a legal process. And because the rights of the individual, certain rights of the individual can be taken away, the civil rights, a lot of them, we have to demonstrate that the individual is not capable of making sound decisions on their own. And, then, that's there again, the alternatives to guardianship should be pursued. We talked about the investigation, the filing of the petition, and the hearing and the summons. So I think I'm repeating myself or clicked on the wrong tab. Yeah. So then on the resources, we just have links to Adult Protective Services, the ARC Master Trust, the Bureau of Developmental Disabilities, Indiana's Long-Term and Ombudsman Program, the Guardianship, Indiana State Guardianship Association, and then the National Guardianship. So that's a good read for anybody that can't sleep at night and wants to get put to sleep sometimes and navigating those things. So let's see. Let me go back up to the referrals. Most of our referrals are agency referrals, and that is either someone from a nursing home or a residential provider or a case manager will contact us about making a referral of a person that's on their caseload or that they are currently serving. And so the process usually is that that you call our number here at the office at 422-6441. Or the email there is info@mhanortheastindiana.org. Gives you that a link to do that referral process and the referral form. is there along with the physician's order, which we need to do. The referral form gets updated from time to time because we learn from experience that as we've gone along and our program has developed, just some things as we, present our cases before the court that we did not maybe ask for the right information. So this is the referral form that you're directed to when you're wanting to make a referral to MHA, and it's real important that all this information gets filled out for us to expedite the process. And if that means that you have started that, but you need to get together with the residential provider and their medical staff or the care plan staff at nursing homes and stuff to be able to do the majority of that. As a case manager, you probably already have a lot of this information in your database, but a lot of the sections that get left out a lot of times is the care team and their contact information, and then people understanding that our criteria is that a person have Medicaid or Medicare and Medicaid and Medicare and Social Security already established. A lot of nursing homes refer to us and want us to do that case management piece of getting somebody eligible for that, and we just don't have the resources or the manpower to do that. And so there have been cases where we've worked with the nursing home, especially if they are pretty confident that that person doesn't have any property or assets. But we have taken on some people that we found out later on had a house in Ohio somewhere and needed to be liquidated, and so that really that's why that income and assets section there is asked. If anybody has any of that, to do that. I don't really have a good search engine to be able to look up people and see if they might have owned a house, or especially with people in nursing homes. They may be hospitalized and then discharged into a nursing home in Indiana that live in Ohio, Michigan, or Illinois, and then somehow they've worked their way into Northeast Indiana, and then after the fact we learn that person may have some of these assets that weren't taken into account, and that's why we kind of require that's the Social Security office can take care of a lot of that for us when somebody's applied for that. But that means that somebody's putting in those that manpower and those hours. And then it's real important to know if anybody as part of the record has a rep payee or a power of attorney or a healthcare rep, because before we file for petition, we need to know and contact that person to see if they want to continue in that role, and just what's the reason why the referral was made to us. And we run into that more so in the nursing homes than we do for anyone that's receiving Medicaid waiver or living in a traditional group home. Again, meaningful day, and then gets into the medical history there. Real important about the significant medical history and the changes in the last 90 days or hospitalization. And then this is real important. We just, we need to have the mother, father, siblings, or any family members that may be still living. And then the individual capacity. This is kind of a baseline for us to review when we get that referral, so that when we go and do our face-to-face with that individual, we're not having to ask a lot of questions that people might not be available, and that we've wasted our time showing up because the individual's not able to answer those in a valid way. So we really, depend on the information and a working knowledge of that professional in those care settings to give us this baseline. And then the notes, and this is very helpful. And then someone to sign that. Sometimes if you do that online, you don't have the ability to sign that, but if you can do that at all, that's very nice. So that's the referral form that we first receive when we are considering someone for submission. Um, um, the physician's report then is also another document that needs to be actually printed. You can fill it out online up to the point anybody can fill it out, except it needs to be signed by the physician that's declaring. This is our current one that's on our website. There's some debate about a state form that is an approved state form that nobody is implementing right now because it's not been mandated. But basically, it's a physician has reviewed this person and seen them, and is saying that that they are not, based on the examination, able to, are not able to make major life decisions. And so it's very helpful not just to say, well, they've got MRDD or IDD or mentally ill, but that, what is the nature and type of the cognitive mental disability and why that impacts the person's ability to make decisions for themselves, because you can have a diagnosis but still be, a fully emancipated person with the supports and team in your life. So number two is not part of our criteria, so we don't look at kids under the age of 18. Sometimes we get referrals from the Department of Family and Children or foster care of kids that have a disability that are aging out, and usually we have to report to them that state entity has to make those decisions for the person and have them placed in a 24/7 residential facility that's fully supervised for those hours. That's our safety net. And so that a lot of times does not allow us to serve a person that would really need a guardian, but they have a mental health issue, but they are still living on their own in the community in an apartment. That's maybe getting some case management or some services from Park Center or Parkview Behavior Health, but we just can't take on those types of folks just simply because we don't have the manpower to manage that and the influences that they can expose themselves to. So and so then if this is all filled out either by a social worker or someone that's part of the care team, it just needs to be printed out and have the original signature of the physician and the address. The form that the state is proposing that we use is really much more complicated, and it's getting into the physician's training and licensure, the license that they have, and all kinds of things. And our experience has been that we have a hard enough time for physicians to fill those out correctly in the first place. And so, that's part of the process, and the delay of the process sometimes is that we know that we don't have exactly what we need to be able to file that petition to the court. Just some background information to let you know that Mental Health America does the guardianship program. We are considered, for lack of a better word, a corporate guardianship, so that when we go to court, Mental Health America is named the guardian, and then the staff that we use, are professional guardians that have been certified by the National Guardianship Association within after the first year of employment and doing guardianship. They have to study and take that test to move forward, and so a lot of times the professional guardian, or what I call the guardian of contact, is with Mental Health America, is the one that goes to the court and is driving the process for the individual. I've assigned it to them and to their caseload, but they are not the personal guardian. They have not taken that on. That's Mental Health America as an agency, a nonprofit agency that has taken that on, just for the continuity of care. Because as you know, in this business, people come and go and change agencies and everything. And so if we're going to go through the process of getting guardianship, we want to have that continuity, that someone, once we have guardianship, Mental Health America that someone will be following that person and participating in that person's life. Another aspect of the VASIA program, down in Indianapolis, they call it DASIA, so tomato, tomato. But there's a component there within the grant that we use volunteer advocates, and so we recruit and train volunteer advocates to be our eyes and ears to do those face-to-face visits with those individuals that we've taken on in the nursing homes or in the group homes. But it's the guardians of contact that I have assigned to their caseload that come to those plan of care meetings, those annual ISPs in the group homes and in the waiver setting, the plan of cares, to make those those decisions, to have the authority as a representative of Mental Health America to sign off on that and those consents that are needed in that annual paperwork update and all that stuff. So that part of the benefit of that then, as far as agencies are concerned and case managers are concerned, is that you're not sending out paperwork that needs to be signed and it's sitting on somebody's family member's desk somewhere thinking that they'd get to it, and then you guys are having to follow up. We make it a priority to try to get that paperwork signed and back to you guys and to the providers or whoever's asking, and as soon as possible. So and usually that's within 2 or 3 business days before we get that turned around. If not immediately, right there at the meeting before we leave that planning meeting. I had another thought that and so part of our duties, as guardians, when we get guardianship of a person, we determine and monitor the residence of that person, and we consent to and monitor the medical treatment. And then we consent and monitor non-medical services such as education or counseling, and so that that includes the Medicaid waiver plan, and as far as goals and objectives and stuff, we have the right to do that. Then we do make end-of-life decisions. It's a policy of Mental Health America that all of our clients are full code. Unless it's been stated otherwise when they did have capacity. For those folks that live in the nursing homes that was functioning at one time and has that documentation, we honor those wishes. And then we take it on person by person basis. Whenever something happens, a crisis, medical crisis happens or whatever for that person that's needing that full code status changed, we do that at the time that it's being presented. And trying to fully investigate exactly what is in the best interest and wishes of the person as much as possible. And that's where we rely on, the IDT to help us a lot of times, because by the time we've come on, sometimes the IDT has been, in place and has that background and history with the client. And so we, really rely on that information from the team. And then we can act as representative payee. If we go and get guardianship, a person and a state, and the people that we do that with most of the time is because, we know that for sure that they, that they're just reliant on state benefits, and but most of the time we just do guardianship of person for Mental Health America. That's not a typical guardianship scenario, but that's what we do here in Northeast Indiana. And that allows us to do all those other things that I just mentioned earlier, so that we usually partner then with the residential provider to to act as the financial rep payee. And then we, but as a guardianship of the person, we do have the right, as if we were that person, to review and look over those records. And we asked of our providers that they send us those monthly or quarterly statements, bank statements, and monitor how that person's money is being spent. And so that can get kind of tricky sometimes, but it's a good thing. It's a good check and balance thing. And then part of the Indiana Code and VASI agreement is that we report to the court. The Indiana Code says that we do at least annually, especially if the person had any assets, which most of our folks don't. But depending on what county court is involved, depends on how they receive that and when they want to receive that. But it's typical. Our standard operating procedures is that for someone that we take on in VASIA, it's a requirement that we do a 30, 60, and 90-day report, and then annually after that, just as good practices. It doesn't. Sometimes it's like biannually or whatever if there's assets involved, and we haven't practiced that too much since we are mainly guardianship of person. I think that's about it. I think I've talked you guys' legs off there. Does anybody have any questions for me that I haven't addressed or need to?
Yeah, we have a few questions for you, Joseph. So
sure.
Hold on. So what about pro bono in rural areas? We have issues for families here in Marshall County. So like
in
pro
Marshall
bono.
County.
Yeah.
I am not sure. A lot of times most of those county has some kind of like, here we have Indiana Legal Services, which we use for some of the outer counties that volunteer lawyers program is not in. So for Allen County and for the counties that VLP does serve, that we usually, that's who we go through and that's who we refer family members to. But counties outside of the Northeast Indiana catchnet, I'm not sure exactly. Most counties do have some kind of like Indiana Legal Services program that's for folks that have limited income or would find that the legal process would be challenging. Typically, it takes anywhere, depending on the lawyer and what people can get done, it takes $3,000 to $5,000 to go get guardianship. In some of the outer counties, it could be less than that, and then it's up to the judge's discretion to you can work with that attorney to waive court cost and everything like that, and then so it becomes a little bit cheaper than
Right.
just going out, and getting a lawyer. I will say, because one thing that we want to be sure that we are good at is that when Mental Health America becomes guardians, we in Indiana Code allows us to do what they call reasonable compensation as a guardianship fee, and so we do charge for the guardianship fee when we can. That's typically anybody that's in a state bed, considered a state bed with Medicaid, whether that be a nursing home or a traditional group home. So far, we have been pretty good about residential agencies that are doing waiver services to absorb that somehow without taking it away from the person's personal spending amount that they get from those benefits. With a Medicaid, with a traditional group home and nursing home, that's considered a state bed. So once we have our guardianship papers saying that we, are serving as guardian, we can file that with the Centers of Medicaid, and they adjust the liability for those individuals. And so it's not, that $35 is not coming out from that person's personal spending money that they get each month. Is how we do that. But we don't have that with the waiver because the waiver is not set up to do that and to offer, guardianship as part of the budget. And so, we are really dependent on the kindness of residential providers doing the waiver services to do that and still meet the needs of the client that we're serving.
So exactly like what counties does Mental Health America currently cover?
Okay. Yeah, we cover Allen County is where we started, and we took that waiting list that we had maintained for years when we first started in 2015 and had 14 people that was still a valid referrals needing guardianship. So we hit the ground running and was able to get, those people through the court process and get guardianships for. And so then that's when, that kind of impressed Indianapolis, I guess, and they wanted us to expand into some of the outer counties or surrounding counties. And so so each year, each contract year, it's a grant from the Supreme Court, and and it's renewed every year. And so we our second year we did um, uh, Adams and Wells, so the south of us, and then going kind of clockwise. Then we just recently last year got Huntington and Whitley and Wabash, and then we have Noble and DeKalb, and then we jump up north just because of referrals. We were just the referrals that we were getting from those counties, and then we serve Steuben at this point in time. So we serve 9 counties total and those 8 surrounding counties. I think I covered them all. So now we do have from FSSA, the people that moved out of the developmental center or had been placed out in the downsizing process. We do have folks that live in Kosciuszko in the traditional group homes with Cardinal Services, and we have somebody as far as Fulton and Porter County, but that they're not part of that funding stream with VASIA. They were that FSSA closed program, and so we travel over there to visit them or try to get them connected with volunteer advocates to be our eyes and ears on a local level, and then try to see them at least one quarterly as the guardian of contact, one time quarterly, but the other times we're using the advocates to visit at least twice a month on the VASIA program.
So like in other areas, say like the St. Joe, Elkhart, is there a comparable program to Mental Health America, or is that someplace that you as an agency will eventually be going to?
No, well, it's the plan for the Supreme Court or the guardianship, the state guardianship office, to have a program in every of 92 county, whether it's mental health doing Northeast Indiana or whatever. But there are other programs, and just in this last grant cycle, I think there's 20 throughout the state now that is serving. I can't remember how many counties it is, but like for the St. Joe and Elkhart area, there is there are other programs. Let me see if I can find this real quick for you. Way up in the corner, north west corner, there's the Franciscan Health Hammond VASIA program in Hammond, Indiana, and they serve Lake County. And I don't know that I have the most updated list, but I could get, that's something I could probably get to you guys.
That would be really helpful for my staff.
Yeah.
Because we do have a lot of individuals that we serve, especially in that St. Joe, Elkhart corridor.
Okay.
And we cover all of Northeast Indiana. So being able to give them a list of agencies would be super helpful. So I'd appreciate that. Yeah, you can email that to me and I will send it out to all attendees.
Okay. Just to tell you over the phone, Real Services Incorporated is on 1551 South Michigan Street in South Bend, and they do serve the counties of Elkhart, Kosciuszko, Marshall, and St. Joseph counties.
Okay. And so services should be fairly similar to what you are providing.
Yes. Sometimes, because we can kind of design, the target populations. But I know, those agencies may have different people. Like I said, the one down in Indy, the Elder at Risk program down in Marion County, they just take APS referrals and hospitals and nursing home referrals, I think, is all. They don't really serve the IDD population so much, that are younger. So yeah, that's yeah.
Okay.
I'm looking here to see if there's anybody else that I could refer you to. But yeah, I will email that to you. Try to get the most updated one, because I know that we did add some programs, but they were mainly in the south of Indy, and in the central part, like Howard County, Kokomo, Grant County. Those didn't have programs before, and I think we're getting at least a upstart in some of those.
Okay. What documentation is needed to get guardianship for a minor?
I'm not real versed in this, so don't quote me on all of it as being exclusive. But I do know that all the school records, any assessments and valuations that has stated the disability of the person functioning under, anything that like the Department of Education would need and should have, is in the school system. I think it's a little trickier for younger kids that are not in the school system yet. That would be a question for Mary Ann Roach at the Volunteer Lawyers Program, since she does help families like grandparents that are go and get guardianship of their grandkids, because their children aren't able or capable of doing so. And so I'm not really sure exactly all that, but I just I know that if you're determining on the person with a disability, and then we're looking at just kids that are not emancipated yet because they haven't turned 18, and so but they do need a guardian involved, or someone that has the legal authority to make those consents and stuff medically for them.
Okay. Do you have to update guardianship paperwork if somebody has moved from one state to another?
That is part of our reporting process. Oh, you said one state. Excuse me. Let me back up. Yes, because guardianship is only as good for the state that you got it in, and the person that when you go to court, they have to be, you have to file with the county court of where they live, the county that they live in. So once they move out, or once they even leave, we've had some horror stories there where somebody was under guardianship, and not for us personally, but and then ended up in South Carolina or whatever, and got in trouble, and the guardian was trying to work with the agencies there and stuff, and they were like, they would not recognize her power as a guardian in Indiana of this person to release information to her, or try to assist her in any way outside of just being that's good to know, that if we're getting back to Indiana, then maybe you can drive that process. But yeah, so the guardianship is only as good for the state that it's granted in.
Okay. Does guardianship have to be renewed every 2 years once established? I have a family that states they have to pay $750 every 2 years to keep the guardianship in place. I've never heard of that.
No. I know that if they're if they've got assets or trust or whatever, for the person they have guardianship for, the lawyer they're using may be charging that for for them to do that report to the court every 2 years. That's the requirement. But I that's beyond my scope. So I'm not quite sure why. Once we get guardianship, and we do that 30, 60, 90-day under VASIA, and have continued to do that annually for all of our folks, regardless of the funding stream. That's just something that we use pro bono lawyers that we have in place to do that. With the e-filing with the court system now, it's easier than ever, and so we just do that, and then count that as pro bono volunteer hours, and to meet some of our grant requirements. We we ask the lawyer to assign a value to that, as far as manpower time, and then and what the rate would be, and that's what we use as in-kind, kind of in-kind claims on our grants, is how we handle that.
So what is the process for somebody who has a guardian who is either in the process of passing away or has passed away, and the person needs to get a new guardian?
If the person's in process of needing a guardian and they meet our criteria for Mental Health in America, they're in a 24/7 facility or whatever, we can take on, you can work with that person and they can agree and sign a paper that says, that, they think Mental Health America is appropriate to step in as guardian because they're no longer able to. And that's kind of the quickest process, as far as everything going on. We have run into some cases where the guardian has passed away, and trying to locate that documentation, because usually right now we have a state registry with the Indiana, so anybody that gets guardianship, they're registered, that anybody can look up, and any nursing home, hospital, anybody, see if this person's under guardianship and who it is. But that only happened about 3 years ago, and not all the counties bought into it. And so, there was an online service, and so, so Indiana's slowly, getting better and better about that. But for guardians that, had guardianships that were established, a long time ago, the court didn't have a record of that, or it's, in archive somewhere that you can't get anybody at the courthouse to go look for. So, and so, we just need to testify that and make sure that's part of the petition, that this person was once under guardianship, but, either those documents weren't located or it's not registered, and that the person that, was named guardian is no longer available, and this person's still incapacitated and needs someone to fill that role. And then usually that, the lawyer works through that, but, we need to know that ahead of time. As we petition the court, so the court's aware that that's the process we're going through.
Okay. Well, I don't see any other questions, and it's almost 11 a.m. on the nose. So I thank you so much for your time today. Really appreciate it. Good information. When I get the list from Joseph, I will share that with everyone who attended today. You will not get a certificate of attendance for this webinar. Instead, you will get an email thanking you for attending, that you should be able to submit to your agency if you need credit hours for training. And again, Joseph can be reached at Mental Health America, and you saw the website. Lots of really good information and documentation there. So please take advantage of that. And again, thank you all. And thank you, Joseph. Have a wonderful day. We'll go ahead and sign off.
All right. My pleasure. Thank you.
Goodbye.